Watson?
Yes.
Mr. Watson, you're charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. As you can see, your lawyer is here with you on Zoom now, so you're not alone. Okay.
Yes, Judge. On December 25th, 2024, officers arrived at a hotel in Harris County, Texas, in response to a burglary of a habitation report. The defendant had made the call and was waiting in the hotel lobby. One moment, Your Honor, let me double check.
The defendant made the call.
As well, I'm gonna read the DMs to see if maybe there's a typo in our summary.
Actually, I think you see the one time.
I believe he did make the call, Your Honor.
Yes, Judge. So the defendant had made the call, was waiting in the hotel lobby. The defendant advised he had a weapon and ID in his backpack. The police then escorted the defendant to a hotel room to retrieve his belongings and then off the property, where it was determined there was no weapon in his backpack. An officer performed a search of the defendant and found an unholstered pistol in his pocket.
What? They just start searching? What's he doing wrong?
I'm going to read the full DMs, Your Honor, because Your Honor, if we could have a moment so I could read this, because it seems like there's a lot more information that
Let's just read the DIMS. That's all I want to know.
the entire DMs, Your Honor. Yes, Judge. So the officer dispatched to a burglary of a habitation, later turned to an evading call for service at a hotel known as The Element. Upon arrival, the officer made contact with the defendant. The defendant was observed behind the front desk area and did not at first advise he was the caller. The defendant appeared in a nervous state of mind and at first was not forthcoming with information for the investigation. The defendant later advised he obtained a room with another person who he advised he did not know and was only known as Chaz Burke. And the defendant advised he had traveled to the room with Chaz, and upon entering into the room, there was a third male in the room already, and the defendant advised he left the area out of fear of another unknown male. The defendant advised the third male was invited to the room by Chaz, and upon briefly speaking with the front desk employee of the business, advised the defendant prior to arrival was located in the hotel lobby, only in underwear for a brief time, but advised he heard a firearm being racked, chambering around, but did not observe this action and only heard it. The employee then advised an unknown female traveled to the hotel, brought the clothing the defendant was observed wearing on scene, which was the sweats and bottoms. The defendant advised the handgun was of his when asked was located in his black backpack. He was observed to have on his person. The backpack was temporarily taken possession of by the officer for safety due to the defendant advising a firearm was located inside the backpack. The defendant on scene had advised and given consent that the handgun could be obtained from the backpack and checked in TCIC, and also advised his ID was also in the backpack and could be obtained on scene by law enforcement. The room the defendant and Chaz had booked, which was number 424, was checked for Chaz or other unknown suspects with negative results, and none of the other suspects were spoken to during the investigation. The defendant advised he was traveling to the secured room in order to obtain any of his belongings in the room due to the defendant was to be criminally trespassed from the business and escorted off the business. The defendant at this point began to walk away from the deputy and continued to attempt to walk away from the deputy, but ultimately the officer escorted to the room without incident. Once the defendant was located back downstairs outside of the business, he obtained his driver's license from his backpack, and as he was conducting an NCIC check on the defendant, one of the other deputies on scene advised the handgun was not located inside the backpack as stated. The defendant was patted down for weapons on scene, and the deputy discovered a black spring-filled handgun located in the defendant's pant pocket without any type of holster for the handgun. The handgun was temporarily taken by the officer for safety. At this point, another deputy arrived on scene to detain the defendant, and the defendant was observed to be in a highly nervous state of mind, and the defendant pulled away from the deputy.
Detain him for what purpose? What's he doing wrong?
So he was being criminally trespassed, and then he had previously...
Yeah, but you give him notice and then you get him to leave.
He told the officers that there was a weapon, and the employee told them that there was a weapon, so they were patting him down because they had those facts that there was a weapon, because they didn't find it in the backpack, but he had just told them that there was a weapon somewhere. So they patted him down for safety, and that's where they found the handgun.
Okay.
I think, Judge, like you said, they have to give him some kind of notice that he needs to leave the premises, just them suspecting that this might be a criminal trespass.
Well, hold on. I mean, but this isn't evading. So at some
Yeah,
point,
I think-
he allegedly must take off.
And as it continues, so once they attempt to detain the defendant for officer safety due to having the handgun without declaring it, the defendant was in a nervous state and he began to pull away from the deputy and began to flee the scene and evade deputies on the scene. So all deputies were in full issued uniform and the defendant was given verbal commands to stop and refused all commands given to stop and continued to evade, which he was then pursued off the hotel property and onto an apartment complex. The officer continued to pursue until he lost visual sight of the defendant, and the defendant was then later positively identified on scene from his driver's license, the Illinois driver's license. So after they attempted to detain him, following that, that's when he ran from the officers.
Matt, do you have anything?
Well, I don't really understand why they were trying to detain him.
Well, I think at the end of the day, I think that what they were trying to do is perhaps they believe something nefarious, right? So they're trying to just trespass him out, which I think is well within their right. And had that just happened and, you know, I think it would have been just, nothing else would have transpired. But the fact that due to him leaving, they're unable to perform the trespass, right? And I think that's, you know, it's problematic.
Okay.
Yeah, so Mr. Watson, I'm going to find that there's probable cause to go forward with your case. I'm not going to put any conditions on your bond. Just be careful. You know, you get into a pissing match with people. It's, you know what I mean?
Yeah.
So you got a lawyer. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but just stay in touch with Mr. Horak and he'll tell you when you have to come back.
Okay.
I know that you live in Ohio?
Yes.
Right, so I'm going to waive your appearance. You don't have to come back. At some point, if you have to come back, Mr. Horak will let you know, and then
Okay.
we'll go from there.
Okay.
So for now, I'll just have you sign a reset with Victoria, and then we'll just get you out of here.
Okay. Thank you.
Judge, how's April 1st through the 3rd?
April 1st through the 3rd.
The second would be great, Victoria.
Got it.
It's yours.
Thank you so much,
Okay,
Judge. May I be excused?
You got it. Have fun.
Take care.
You can put them to me?
Ready when you're.
So there.
Cesare? You, Mr. Cesare? Sir, you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement. They're offering you 12 days in jail with credit for the 4 days that you've done. You need to understand that this charge will go on your record. It's going to be there for the rest of your life. You can never take it off. Do you understand? Yes or no? I need to know that you can actually understand what I'm saying.
Yeah, I can understand what you're saying.
You also need to understand that from now on, you're facing a minimum of 30 days in jail for any new cases that you pick up. You're giving up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, you can never change this or undo this. You understand? You still want to do this?
I guess I am choice.
You got to be sure. There's no wishy-washy here because, you know, once you do this, this isn't like Target. You could just return it because you don't like it anymore. Once you plead guilty, that's a lifetime decision you make. There's no turning around. Your other option is to go to trial. Those are the two options that you have.
Whoa, listen to that tone shift. The judge just dropped the hammer. This isn't Target. You can't just return a guilty plea because you changed your mind. That lifetime decision line hits different when you realize a criminal record follows you forever. If you're watching this thinking it's just trespass, remember, one bad choice today can close doors for decades. Would you take this deal, or would you roll the dice at trial? Drop your thoughts below. I want to know what you'd do in his shoes.
Then we go to trial. So
This
I'm
isn't-
not going to plea him, Your Honor.
This is not, it's not a game. It is, you know, so you either are or you're not. Reasonable minds can differ. The evidence points to whose side is correct. I haven't seen the evidence. I have no idea. When we get to trial, that's when we all get to see the evidence. But there may be, body cam, there may be videos, there may be eyewitness testimony. I don't know. But until we get to trial, I'll never know. So, you were allegedly there at the time. I have no idea. You either are or you're not.
I was visiting.
Look, I don't want you to talk about the case. You just understand, a lot of people try to justify things by what they think is right. Even though if you think something is right, if it's still against the law, it's still against the law. I don't know. That's why we give you a lawyer, for the lawyer to tell you what the law is, what happened with your case, and whether you are in fact guilty of the offense charged. I don't know. If you want a little bit more time to talk to Greg, you can. It's up to you. But, once you do this,
Speak with him here.
yeah, once you do this, there's no turning back.
What was his last name?
Cesare.
Thank you.
You? Come on up, Mr. Cesare.
Sit there.
Radio Gospels?
I haven't talked to the attorney though, so I don't know.
Are you guilty of the offense of criminal trespass? Okay. Just understand that, from now on, you're facing a minimum of 30 days in jail. I don't know where this is from, but if you go back, chances are it's going to happen right again. So I don't know where this is from, but I probably wouldn't go back, because if you do, you're asking for trouble.
It's an apartment complex owner, just so you.
I wouldn't go back. Just don't. Even if someone invites you, I wouldn't go back, because they're going to call the laws are going to come, and they're just going to mess with you. You know what I mean? That's just the reality. Now, like I said, you give up a lot of rights. You give up the right to a trial, right to compel citizen. There are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So no more trials. We're done today. All right? Okay, man. How do you plead? Guilty or not guilty?
Guilty.
I'm going to find you guilty. I'm going to waive your court costs so you won't owe anything. Good luck.
Just gonna give you a form, you go downstairs, you're done with this, cleared out. All right?
Okay, guys.
Thank you. Go right there. Come on, I'll show you.
Give me a second. Come on up, guys. Okay.
All right, Judge.
It's rollers.
Page 3, Arenas.
Folks, you ready? Come on, let's roll. This is Aminita
Yeah, Arenas.
Arenas.
Yes, sir.
You speak English.
Yeah, I do.
Ma'am, you're charged with tampering with a government record. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. Shh. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Quiet.
So,
Shh. The reason that we have you in custody now is that you were on felony probation for injury to your child under 15, and it looks like they've issued a warrant on that case, and it's now set at no bond. So we have to take you into custody because of
but
that.
how if I was like,
Well, hold on. I don't know anything about it. I'll appoint you a lawyer. I will have the lawyer talk to you about how we can go forward. Let's first do probable cause in this case, and then we'll go forward.
Yes, Judge. On January 30th, 2025, at approximately 12:23 a.m., the officer observed a vehicle traveling with high beams activated within 500 feet of oncoming traffic. A traffic stop was then initiated, and the officer made contact with the defendant, the driver and sole occupant of the vehicle. The defendant provided a Texas ID and advised she is uninsured. The officer ran on TLETs, a search on the temporary tag, and could not find any records. The officer conducted a TLET search on the VIN and could not find any details, nor could dispatch. The officer was able to run a VIN through the Carfax and it came back to the same year, make, and model of the vehicle. And the officer ran a temporary tag through a management system and it showed as being involved in an accident on January 22nd, 2025, but showed as a silver 2005 Nissan. The defendant stated she bought the temporary tag from somebody and that the vehicle was dropped off at her work and mentioned that they had a silver Toyota Solaris and the Nissan Titan. The defendant observed a male swap temporary tags.
She's charged with tampering.
Yes, because she would have been aware that she did not purchase a valid registration as she saw the person she bought the vehicle from swap his tag to her vehicle when she bought it.
Say that again, I was reading something.
So she knew that she was not having a valid registration placed on her vehicle because when she purchased the car, the person she purchased it from took his registration from his vehicle and put it on hers, and she continued to drive hers, knowing that it was not the proper registration.
So then and there unlawfully, intentionally, knowingly presented and used a license to which attached hereto as Exhibit A, a governmental record with knowledge of its falsity.
She saw him swap it from his own for hers.
Right. All right, so ma'am, I'm going to find that there's probable cause to go forward with your case. And what I'm going to do now is, did you say that she has a Texas driver license or she does not?
All right, Your Honor. Okay. It's eligible, Your Honor.
So she has a license then?
Yes, Judge.
Okay, great. So what I'm going to do now is I'm going to put you back. I can't let you go because there's a felony warrant for your arrest.
Why
I will
with
appoint you a
the-
lawyer and the lawyer can explain to you why the warrant was issued and how we can go further.
But if I was in operation every month,
I'm sorry?
I was in operation every month, she didn't tell
I
me.
get it, but one of the things while you're on probation is don't pick up any new cases, right? So let's do this. I can't give you legal advice. I can't tell you how to go forward, but I'll give you a lawyer today and the lawyer will tell you and give you more advice, okay? For now, I just can't let you go. There's a felony warrant. So we'll put you in back for now and then I'll appoint someone to you, okay? Please. Can you file no, hey, hold on, Vic. Can you no license and valid insurance?
Yes, sir.
As of our information, please. Okay, I'm sorry, go ahead.
I am approaching to see if we can amend bond conditions for two cases, actually. One of them is off docket. Is that okay? Can we-
Yes, absolutely. Good
Okay, I have the
morning,
case number.
What is it?
It's 254-9067.
A Wong.
Yes,
Okay.
he is here. He had the no contact with the complaining witness restriction and also the address. He lives at the home, he pays the bills. We've spoken with the complaining witness and they said they're okay with no threatening and harassing and allow him to go back home.
Yeah. Sorry,
What say you?
yes, Judge, I confirmed with the complainant, they want him back home and, we were just asked that.
My only issue is that he's a prior murder case.
Not yet.
Yes, Judge.
What happened with him?
So many years ago, Judge, but he has not had any issues since. I do understand the concern. I
would typically be more concerned, I think, given the age of the murder, as well as the fact that that is his primary residence. I think it might be fair to.
Come on, Wong. Oh, it's not on docket, you said, right?
No, it's not.
So all we're doing is taking off the residential restriction, correct? That's all we're doing? Or is there's a no contact order now?
But they live together, so,
Who is the complaining witness in this case?
his girlfriend's son.
Yeah, I mean, we can do,
Have you ripped to see whether the son wants to have contact?
yeah, that's the person that I.
How old is this kid?
He's,
47,
yeah,
Judge.
he was.
Okay, so he's not young. All right. All right. So Mr. Wonk, they're asking me to amend your bond conditions to allow you to have contact. I will. I'll allow you to go back to this house, but you need to understand there are still conditions of no threatening or harassing behavior. And what you need to understand, what threatening and harassing doesn't matter what you think. I don't care what you think. It's what the other person perceives. So you need to be aware of this. I don't know what kind of relationship you have with the complaining witness, but if it's something where you're constantly butting heads, that could be problematic for you. All he has to do is just call and say, hey, man, he's at it again. You're the one that's going to go back. You understand? Okay, so just be careful. There are many vindictive people in this world. Know who your audience is at all times. So do you mind filing those? No threatening or harassing and no weapons? And then if you don't mind printing out the memo for me, I'll amend it then. Okay, Mr. Wong, we're going to need you to sign bond conditions reflecting that you understand everything. Just take a seat. Once we have you sign it, at that point, you're free to go. Okay, thanks. Oh, yeah, it's 254-9067. Yeah, okay.
And then I have one other on docket, Hodges. He may not show. We reset him for today to amend the bond conditions, but he's on docket. I can give you the case number off if you need it.
Yeah, it's not on docket. What's your cost number?
It is 253-2980.
Okay.
Oh, I guess it's
So this is a failure to give information.
Yes, so at his arraignment setting back in October, you did a no driving, and then we also put a curfew on it. He has been on those conditions since. He's done a defensive driving course. He hasn't had any bond violations or anything within that
Okay,
time.
is he here?
Yes, sir. Can I take these already? It is 253.
Come up, Mr. Hodges.
Thank you. We're just asking, so like the no driving restriction and the curfew.
Does he have insurance as well? Have you been, do you have liability insurance in your name?
Car insurance?
In your name?
Yes.
You do have car insurance in your name?
Yes.
As long as you have a Texas driver license and liability insurance, but you have to have it in your name, right? At that point, I'm going to allow you to drive, but you need to understand that it's a privilege. It's not a right. So if I see you acting a fool in the car, I will take it away again, and I'm not going to do play this game again with you. Do you understand? Okay. All right.
Thank you, Judge. And the curfew,
Does he have any other open cases elsewhere
he
too?
does in Galveston,
Yeah, over there?
a DWI. However, I mean, he works, he's an electrician, he works 2 hours away. And so the curfew hasn't allowed him to work any overtime or any late nights.
How long do you want? What do you want?
Can we just take it off completely? I mean, he's been on it since October, and he's shown that he can be consistent and that he wouldn't have any trouble. Looking at it now, I think he deserves a second chance.
Okay, we'll see. If you pick up a third case, I'm going to absolutely lose it. Do you understand? Make good decisions. We're not asking for much. You endanger my public. I'm going to go nuts on your bond. Do you understand? Okay, all right, we'll give you a chance.
Judge, we're removing the DPS completely, correct?
Correct. All right, Mr. Bonds. Hey,
Mr. Proctor, again on the docket
Okay.
for, he's got a
is he back there? Okay.
reported bond on his terroristic threat, raise it to 7. Would you lower it to 5,000?
Yes.
Okay.
Yeah.
And then,
So hold on a second.
conditions,
What's it now? It's at,
7,000.
so what I'll do is, 5,001.
Okay. And then conditions on the, DWI,
Just standard conditions. I mean, does he have any other, do you know if he has any other DWIs?
no, I don't think so.
No, Your Honor.
Okay, so just no alcohol, no dope, no weapons, no contact with the complaining witness in the terroristic threat. Just standard bond conditions, but let him know. If he picks up a third case, all bets off. Right? And then, Mr. Pons, I just sent you an email.
Yeah,
So-
I was gonna ask you, because I did a lot of work to not work that Monday, that Super Bowl Monday.
You want the next day?
Yes. Okay,
Absolutely.
I'll see you Tuesday then.
Yeah, for sure.
All right, man.
I'll let Victoria know. Yes.
How are you?
What's going on with you, man?
Here on Mr. Matthew Adolph, the state just filed a nollie on that case.
Okay,
He's on the way back from,
I'll sign it. I mean, if they're dismissing it today, then there's no need to address anything, you know?
he's on the way back from the VBR. Like that's, they on here and passed, so it's a moot point. So
right.
it should be in your queue.
Okay, I'll send it right now.
All right, thank you, Judge.
You got it.
Maybe excuse.
Yes, sir.
God bless
Thanks.
you.
Hi, Sean, how are you, man? If you want a copy of the nollie, we can give it to you now. I'm signing it now. Okay. Hi, Sean.
I have one. It's the top of page 12, just trying to avoid using the name with it.
Okay. What do you want to do?
So we are working with felony right now, kind of going up the ladder at the DA's office about more possibility of a diversion for upstairs that will, I believe, work this one out. Chris went upstairs and talked.
You represent him upstairs?
Yeah, yes, sir. Here and
Yeah, we're co-counseled on both of them.
Okay, great.
We feel optimistic about it, but we just haven't gotten a full answer since there's been a change in administration and all that. So everybody.
So did he have a PTI in the first? Is that why?
This is the evading that he's charged with. I have my own serious doubts about, but I think in his interest, he was trying to seek a PTI that may result in a plea in this case. But we're trying to
So,
work out
but
the
it's, the
details.
problem is that it's old.
Yeah.
So how long do you want? I mean, we got to set a time. I got to give you a time limit, right? Just, it's 220 days now.
And can we go about 30 days?
At that point, I don't care. I'm going to set you for trial though.
Okay.
Like you're out of time at that time. You're at 250 days and that, you know, it's just too much, right? So I will give that to you, but that's the last setting.
Okay.
Okay? So do what you can to try to work it out as fast as you can, but that's it.
Okay.
Discovery's complete, right?
No, we are missing the search warrant and search warrant affidavit.
And then I'm going to have a big problem with this. And then I'm going to set this for if you guys are missing something at 220 days, Alex, I'm going to have a big problem with this.
Yeah, Judge, just let me confirm.
Okay.
Regardless, your cutoff day with this case is 250 days. So what I'm going to do is I'm going to set this, if you're truly lacking something, I'm setting this for discovery hearing. And if you don't get it within that time, that's it.
Yes, Judge, it appears we're still missing the warrant, so we'll reach out immediately if we can get it.
Setting it for a 10-day discovery hearing.
Hey, discovery hearing.
You don't have absolutely everything.
Yes,
It's
Judge.
not going to go well for you.
Yes, Judge.
It's unacceptable that at 220 days, you're still missing a warrant.
At that 10-day hearing, will his appearance be required or will it be waived?
You can be waived. It's not a big deal. So we're on top of page 12. They're still missing a discovery. So I'm setting it for a 10-day discovery hearing. What I would do is I would subpoena the officer to come to court.
Yes, Judge. And
Deuces Teacom.
we'll have them,
But
we'll
yeah.
find it your own.
So set it for 10 days, but the cutoff with this case regardless is 250 days. At that point, it's clear trial. So, okay, guys.
Okay.
See you in 10 days.
Thank you.
thank you.
Oh, and hey, Judge.
Hi, Marcus.
Commissioner Gonzalez Hernandez.
Okay. You ready?
I call him up.
Please.
Do you have the cause number?
Yes, thank you.
Our friend, Mr. Martinez, has not made it up, so hopefully he'll come up tomorrow, Judge.
Say it again.
Our guy from yesterday.
Are you posting bond?
I don't think he's posted bond. No, I don't see an ISO, so I guess we'll see.
Really? No one's gonna post it for him? No one's gonna post it?
I don't know yet.
Por favor, conteste a voz alta.
Good morning, Mr. Gonzalez Hernandez.
González Hernández. Good morning.
We're charged with driving while intoxicated. First offense, it's elevated to a Class A misdemeanor because of the high blow. So you are facing up to a year in jail and or a $4,000 fine.
Multa de $4,000.
You guys have worked out an agreement. They're offering you 1 year in Harris County Jail.
años en la cárcel de
that to be probated for 15 months.
meses.
Is this a second or a
Es
first?
la segunda.
True first?
La primera.
As part of the agreement for you to successfully complete this, you must do a DWI education class.
Pase de
You must do a victim impact panel.
tener un panel de
You must also do a TRAS. This is an evaluation to see what other conditions you may need.
condiciones
If
necesarias.
they assess other conditions, you must fulfill these conditions as well. Substance abuse treatment,
También eso incluye tratamiento,
no breath test refusal,
pero
meaning that if you're pulled over while driving a car and an officer asks you to submit a breath sample, you must do it. No drugs, alcohol. You must have a guardian interlock and 30 hours
20 horas.
community service. Does he have a Texas driver license?
He
de
does not
licencia de
You are
manejar.
not allowed to drive. I want you to understand, I take this absolutely serious, and you will be signing a promise with me today as part of your probation that you're not going to drive.
Como parte de
There's
su
nothing worse that you can do in this life than doing two things. Three, picking up a new case, drinking alcohol, or driving. Those things will land you in custody faster than anything else.
rápido.
And if you're not in this country with permission, and you go back to jail, it may be your very well last time that you
Última vez.
are here. Do you understand?
Entiende. I do.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration
Hay
consequences. You can
posibles
be deported,
consecuencias migratorias.
excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty to this offense, it will go on your record. You will never be able to take it off.
Ya sacarlo.
Do you understand?
Entiende.
You also need to understand that if you get pulled over in the future, you're in a car driving, an officer, the first thing they do is they look at your driving record.
Hacen
If they see a prior DWI and they come up to your window and they smell alcohol or they smell something funky, it's not going to go well for you. And from now on, you are facing a minimum of 90 days in jail for any new cases that you pick up.
el caso nuevo que usted le da.
Do you understand?
Entiende. I do.
All right, how do you plead to the offense? Guilty or not guilty?
Guilty.
I will find you guilty, send you to the agreement. Good luck to you, sir.
Buena suerte, señor.
Thank you, Judge.
The fee, the fee.
Wait, the thing, okay, is it?
So, hold on, Tony. I need you to tell him one more thing. I want you to understand something.
Usted entienda
That DWI is extremely big business in Harris County and in Texas.
Grande.
There is a $3,500 surcharge that typically would apply to you
3,500.
on these types of cases. I will waive it for you now because it is a first offense. On a second DWI offense, it is a $6,000.
Boom, guilty on the elevated DWI. The judge isn't playing around. First offense, high BAC, and he just laid out the brutal truth. Pick up another case, drink, or drive while on this probation and you're going straight to custody. Notice how he waived that $3,500 surcharge as a break on a first offense, but warned it doubles on the next one. This is why experienced judges sound so intense on DWIs in Harris County. Real talk. If you drive after drinking, you're not just risking your license, you're risking everything. Have you ever had a close call? Be honest in the comments.
We ordered conditions, but they were not entered. So we're back again.
So let's enter it now and we can have him sign it and that way we're.
Okay, well, there's no notes of the conditions. So if you could please order them again.
Remind me what happened again, Alex, please, if you don't mind.
One moment, pulling it up. Let's see it.
And I talked to Mackenzie, Gary. The judge wants a reminder.
Oh, it's 254. Fine. Yeah.
He's still in custody, right?
No, Your Honor, he's on bond.
Is he here?
Yes, Hodges, please.
So, come up, Mr. Levi. Or is it Levy or Levi?
Is it Levy or Levon? Levy, you're on.
Okay. Mackenzie, do you mind?
Yes, so on January 21st, 2025, an officer made contact with the complainant. The complainant stated the defendant, she knew him from a previous dating relationship. The complainant stated she ended her relationship after finding out she was 6 weeks pregnant and was paying the defendant's phone line until she turned it off on the 21st of 2025. And the defendant started sending her threatening messages on the 16th, 2025, stating that he was going to make somebody jump on you and knock your teeth out, and delusional hoes like you deserve to die. The complainant stated she went to turn off the defendant's phone line on the 18th, and the defendant is now using Wi-Fi to continuously threaten and harass, with the last message on the 21st of 2025. The complainant is in fear for her life, and the defendant was ID'd by his Tennessee driver's license.
Got it. Okay. So he's also on probation. Are you representing him on his probation case upstairs?
That was terminated, Your Honor. It was early terminated.
So he's not on probation now?
No,
So, Mr. Levi, or Levy, I'm ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will put you back in jail. Do you understand? You're not to have any contact with the complaining witness in this case, and you're not to be in possession of weapons as well. Did we do a,
there's a
Moab?
motive. It has not been signed, Your Honor. It's in the system, but it was not signed.
right, so I'm entering now what's called a magistrate's order for emergency protection that identifies Ms. Beck as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot go within 200 feet of where she lives or where she works. Do you understand? If you violate this court order, the state can and will file a violation of protective order against you, and that is the capital murder of misdemeanors. You pick up a case like that, it's really going to go sideways quick. Stay away and control the temper, because if you become a danger to my community, I'm going to unleash on you. Do you understand? I don't care who you are. I don't care where you're from, but I'm going to protect my community at all costs. We will have you sign the order for protection. I'll have you meet with Felicia for bond conditions, and after that, you guys are free to go.
Thank you, Your Honor. I appreciate it.
Yeah, let me give you a cost number. Ready? 254-8452. Hi.
Good morning, Judge.
Come on up.
Ready for approaches? Or
Yes.
still taking
No, no. Come on. We're waiting on lawyers.
Off docket, if I can give you a FOS number, it's on Mr. Chason Booker. It is 252-1808, and I am here to request a modification of bond conditions this weekend. Mr. Booker has guard service, and I have a confirmation he will be in Corpus Christi. So he's asking that the 7th through the 9th, his curfew be modified to 4 a.m. to midnight so he can make it to Corpus Christi in the morning. It's a 4-hour drive from his base.
Okay. All right.
Thank you, sir. And I'll just sit with
Yeah, just let her know, but then after that, that's,
Absolutely, Judge. We're trying desperately to work this out. Thank you, sir.
Yes, good morning, Judge. I'm here on Mr. Adan Vides.
okay.
I can provide a case number if you need.
No, I got it. So what's going on?
Judge, so he's already paid the restitution. He had to do a 2-hour anger management course. He said he was working on it. I believe he should get it done by this morning. I just haven't been able to get the certificate just yet. If we can just have until maybe Monday, I can get the certificate.
I'm not going to do that. I'm not going to do it. He's literally had since November. We're now February 6th. We've literally reset him 2 other times for him to get it done. I'm not going to do that.
I understand, Judge.
He's got to be here. Is he here now or no?
I just messaged him, Judge. He should be in the courtroom. Let me just check, Judge.
Adan Vides. He is not here.
Understood, Judge. I'll contact him and I'll be on standby. I'll confirm that he has that certificate.
Not a problem. Just let me know.
Yeah, thank you, Judge.
Take care.
Judge, my apologies to interrupt. I did get him to send me the certificate of completion and I just emailed it to Mackenzie. I just texted him to appear in court.
Okay, I'm gonna have you send it to someone else. I'm gonna chat you the email, okay?
Yes, Judge.
Hold on, I'm not patient here. And so we just got an email regarding for dismissal. I'm sending you the certificate, just so that, okay?
Yes, Judge.
Just give me a second. Once they file it, then we're done.
Sure, Judge.
You ready?
Yes, sir.
Yeah.
Okay, good morning. I have like 3 on your docket.
Okay.
Or 4. First one is Mr. Forbes. He's entering PTI today. We're
Great.
just submitting everything.
Okay.
Next one is Mr. Pujos.
Okay.
He has a TRAS date for 2/10.
Is he here now?
No, he has a TRAS date for 2/10.
Okay. I guess we'll set it for 2 weeks after, assuming that he goes. If he doesn't go, then he'll have to be here the next.
Absolutely.
Yeah, okay.
Next one is Luis Sanchez de Armas.
What about the mitigation package? Was that something?
Yeah, but he's already been approved.
Yeah, okay.
He wouldn't get a TRAS date if he's not approved.
Okay, tell me about Sanchez de Armas.
Sanchez de Armas, I think, well, they just released a 911.
We just got it yesterday, Your Honor.
Yeah. And then, I think Ms. Siegler wants to look at it again before they make a decision whether they want to dismiss or separate, or.
So I'm gonna do, it's 180 days. We'll do it a week. I'll waive the appearance and then come back.
Sure.
If you are interested in a PTI, then,
No, it's not a PTI case.
no, okay, got it. So at the next setting, if they say no, you're gonna set it?
Yes, sir.
Okay. Who's next?
Well, yeah, that's what I'm going to recommend to my client, and my client will decide.
Sure.
Okay, the next one is Villegas, Your Honor. That's evaluated.
Another one?
Yes. That one I don't think has been evaluated yet.
Okay, so I guess let's do the same thing. Is it the same thing where you're
No,
gonna?
well, again, that one, I'm not sure about, I mean, I'll still recommend it, but that client is, on
So
the fence.
we'll do the same thing, we'll do a week.
Okay.
And then depending on what they say, we'll come back, make a decision on which
That's
one it
great.
is.
Thank you.
Okay?
Yeah.
And I'm not having sign order or something else. Just for the visa.
Yeah.
You're good. I'll come something. You can do it.
Are you ready for me?
You're right. For this, we're waiting on the supervision.
Yes, it's already, I can forward it to you.
Oh, you have it?
Yes, ma'am. I mean, I don't have the supervision order, we just, my office just turned everything on.
Okay, I'll just wait for it to be filed.
Yeah.
What's your next one?
Villegas, and that's Villegas.
Vegas just said 1 week to decide. February 15th.
Judge, I did get that sent over. Did I still need to have defendant appear in court?
Mackenzie, are you ready to file a
Yes.
A nollie on
sorry,
it?
Judge, I thought it was a different case at first. I've just uploaded the receipt and I will follow the nollie right now.
Okay, yeah, you're good to go. They're gonna file a nollie now.
I understand, Judge. I'll let the client know that he doesn't need to appear, correct?
I'm sorry?
Did the defendant need to appear
No,
for anything?
No, they dismissed it. You're
Understood.
good to go.
Thank you, Judge.
Okay.
Have a
Take
good
care.
day.
You too.
Corbus?
Judge?
Great. Yeah.
I mean, if it's multiple, then that's it. Well, no, I'm not playing this game.
Okay.
So it's Jennifer Flores?
Yeah. She was set for writing today.
So SFBF Monday.
Okay. And the other one was Jones on page 20.
And we already did one SFBF, right?
Yes.
Okay, so this one gets, if he's not here by the end of docket, then it gets revoked.
Wow, that's crazy. And the bottom one, I think,
Oh, and he picked up a new case.
well, no, Judge, this was, he was arrested at the same time for both cases, but they put one on Monday and one today. Oh, we did. Hey,
Hey, so.
she wasn't my right. She's on your thing, it's supposed to be, she's not gonna, I'm gonna be the okay, still teams going. Yes. Okay, great. Oh, it is. That's not your. Yeah, that's good. Perfect. Now before recess. I don't think it so I did the I need to be here. So waiting on fire.
I'm assuming that's all.
You know me that? Sure. Right, I'll give you some. Yeah.
Okay, cool.
Just get one. I'll get some much line.
So you could tell. But yeah, very soon. You didn't, well, you don't add,
Jesus, it's history. Oh, no, it doesn't. I'm kidding.
Wow. I think you did that good though in your best days.
Judge, may we approach?
Hi, yes.
We're here on Ronnie Granger.
Ranger. Okay.
We are approaching just for bond conditions.
Did he just get out, I'm assuming?
You want him to come up to?
Please.
I'd be on. Extending the bond conditions.
Can you please read to me what happened in this case?
Yes, Judge. So
On January 14th, 2024, an officer at 3:14 a.m. was dispatched to a disturbance call at 4800 Hollister Street. Upon arrival, the officer made contact with the defendant who was inside his vehicle. Officers attempted to box in the defendant with emergency lights on. The defendant reversed out and evaded in his motor vehicle. The officers pursued the defendant for 6 miles until he lost control and crashed out on the 9100th block of Northwest Freeway. The defendant ran out of his vehicle and the officers were able to chase him down and take him into custody. The complainant told the officer that the defendant was asleep and woke up feeling paranoid and thought somebody was trying to kill him. The complainant tried to calm the defendant down. The defendant acted as if he was going to hit the complainant. The defendant began to follow the complainant around the apartment in an unnatural manner. The complainant started to feel fear. The complainant started to call 911 and told the defendant she was. The defendant grabbed the phone from her and grabbed the phone from her hand as the dispatcher was on the line and hung up. The defendant grabbed the complaining witness's daughter's phone in her second attempt to call 911 and hung up the phone. The defendant grabbed a knife and said, "I'm going to kill you," 2 times, but never came at the complainant with the knife. The defendant left the apartment and went to sit in his car. The complainant went to her neighbor's where she was finally able to call 911 successfully.
I know whether she wants to have contact with you.
Absolutely no contact, Judge. I've spoken with her. It's a very traumatizing situation for the complainant.
Mr. Granger, I'm going to find that there's probable cause to go forward with your case. Do you know what conditions the felony court has placed on him?
They have not placed no contact with it, which is why I wanted to approach with you today, Judge. They have placed disappear, no new crimes, no drugs, alcohol, no firearms, and that is it.
Yeah, because it actually is more.
From what I've been told from the complainant as well, she did get a 90-day protective order as well successfully.
Granger, I want you to understand that I'm going to do everything in my power to protect my community at all costs. If I find that you become a danger to my community, if I find that you try to have contact with the complaining witness, if you pick up a 5th case, I'm going to go absolutely bonkers. Do you understand? You are not to have contact with the complaining witness in this case. You are not to consume alcohol or illegal drugs, and I'm going to randomly test you. If they call on you to go take a test and you fail to go, a warrant will issue for your arrest. If you have any kind of weapons, you go anywhere near the complaining witness, likewise, I will revoke the bond and put you in jail. Do you understand?
Yes.
No weapons.
Counsel, just one minute. Oh, great.
No going within 200 feet of where the complaining witness lives or works. There are no children involved, are there?
Yes, there are children involved, and children were on the scene of the incident.
He has 2 kids, that's his wife, 2 kids, and they're expecting 1. When are y'all expecting 1?
August.
It doesn't matter that you have one, you're not to have contact with this person. Do you understand?
Yes, sir.
You're gonna have contact with the kids, which you very well should, use an intermediary. You can use counsel, you can use anyone else, but don't take matters into your own hands. Don't go over there. It's not going to go well for you. Do you understand? Okay. So you have a lawyer. It is your responsibility to stay in touch with her. If she tells me she can't get a hold of you because you're ducking and dodging, likewise, I will issue a warrant for your arrest. You understand? Okay, so we'll have him sign bond conditions. You guys are free to go.
Thank you, Judge.
Okay, please. Thank you. So Mackenzie, I guess just reach out to her, let her know what the conditions are. You know, give her access to you so that if something should happen, she has a way to get in contact with someone easily to let us know. Okay?
Wow. Okay. I just get at this. I'm about to step out. All right. It's not the same thing. Sure. Council for recap.
Calling Marcos Edras.
Hey, on homeboy for yesterday, you want me to send him for a T-Ride? I can expedite him over to stuff. Chitori, will you, on yesterday's case that we took into custody, can you look to see how soon we could do an in-custody T-Ride? Is it possible to get it done today?
If we still have to have
Maybe tomorrow?
Tomorrow, I have somebody assistance.
Okay. Marcos, he's not here, he's in processing, right? If we get him tomorrow, we can have someone come up and do it tomorrow. And then, you know, we could perhaps even do, how long have we
So.
I don't know about reinstating.
Jail therapy. My concern is high school was done. Because the other offer was, 30 days in jail, which she did not want to go down.
I get it, but I mean, I want to have, my intent was to have the T-RAS done so we know exactly what we're doing because sober court do need sober court, but we need the assessment done first before we can do it.
But it's also doing probation tear down. You have 22 months in your mess. So.
But we don't know what's going on there. I don't know what, whether he's going to get help that he actually needs, and who represents him there, do you know? Because maybe we can, if somehow kind of make them together, or perhaps if they know how arduous and labor intensive ours is, maybe they'll ease up on theirs. I don't know.
Okay.
Well, I'll see if somebody lets them do it for us tomorrow. I think I just extradite it, so hopefully they can get the report done by the end of the day.
Yeah, that'd be great.
Okay.
Yeah. If that's the issue, then perhaps the next day I'm with you.
Okay.
So we know that we can just get it done and move it and we know where we're going.
Perfect. Thanks, sir.
Mr. Preston, how are you? What's new?
I have Mr. Juan Guerrero with you.
Okay.
Juan has an ice hold. He's not going to be getting out of jail. So we'll need to approach.
44.
Where do you want to go now? What do you
With
want to
him?
do? Yeah.
Trying to get a deal for jail time on one and dismiss the other. Kelsey needs some time to check with her supervisor to see whether that would be okay.
I get it. It's only 17 days old, so I can't imagine that they have probably any evidence.
So we're just trying to do a short reset.
Yeah, absolutely. I mean, if you want a week, 2 weeks, whatever you want.
Real short. Judge.
Yeah, just you let me know.
Yes, sir.
Yeah. Eric. Hi, bud.
I'm here on Mr. Washington, first name Michael.
Bond or custody?
Bond.
Okay.
Council for reset.
Okay, what's the word?
He has two cases, reckless driving and a pistol case out of the same transactions.
Okay.
State has offered him PTI with a bunch of things to dismiss.
We got that offer December 23rd, or I'm sorry,
January 23rd.
January 23rd.
So he signed the contract this morning so he can get started on all of the things. So he just needs time to do defensive driving, decision-making, gun safety class, and then $100 donation to the food bank.
Michael Washington, come up. So it's 180 days.
I know, that's why
You know, I'll give you 3 weeks, but if he's not done by then,
he doesn't have to do community service hours.
Right.
It's just class.
so, you know, you've been given a great offer, right? They're willing to dismiss both your cases. All you have to do are 3 classes. Your case is 182 days old. I'm not giving you much time to get it done. If you don't have the wherewithal to have it done within a couple of weeks, I'm setting your case for trial. Do you understand? Okay, man. All right. Good luck. Couple weeks.
Judge,
Hi.
approach briefly.
Of course.
How you doing?
How are you?
I had filed a motion to sub on the accused sub out Mike Snyder.
Is that in your?
Is it on today?
He's on the docket today.
Okay, I'll sign
I
it.
think I didn't have the, and that's been the problem with the Snyder.
Do we have a motion to sub?
I'm not doing one now.
Yeah.
I just-
Just have you talked to Slider yet?
Yes, I've only been knowing him since I was 13. So
The only problem is it's old.
Right, and I know we need to get moving, and I was wondering what happened, because I never could get the information, but I didn't file the order, so that's on me.
Right. Okay, yeah, I'll sign it now. Talk to the state, see where you're at, and then just let me know.
Maybe one reset and going one way or another.
Okay.
I just need to see the information.
Council for reset.
Val. How are you?
I'm doing well, Judge. Thank you for asking. How are you?
You know.
Good. I'm approaching on Lan Nguyen. Nguyen is the last name, Nguyen.
I see it.
State's been attempting to get in touch with the complaining witness. Been a while.
You guys set an investigator in October.
Yeah, and the issue is we need a Vietnamese interpreter because every person we get in contact with, the last person, they don't speak it. So we're
4 months though, you know?
So we'll try reaching out as soon as we can. Today, we'll try to see if we can get in touch with a Vietnamese interpreter, but that's the issue, is we can't communicate. Yes, Judge.
In a week, that's it.
Thank you.
All right, thanks.
We waiting on somebody. We waiting on somebody.
I can help you.
I'm with you.
Okay.
Okay. So, last note we have on this one is that I believe Flyer was the mitigation packet on those. So now it's actually in October, so you know if it will
Happen is my father. That's why I never had this problem with the city.
Okay.
I'm sure we'll make the same thing.
Okay, gotcha. Is it true? Right. Yeah, because
Reach out to you.
gotcha, and that's for PTI, if you want to pursue that. Otherwise, we already have a time serve offer on there. That's why.
But he has a PTI.
Well, contingent first do the mitigation packet, let us look at it, and then we'll determine if.
Judge, may we approach? So he has a PTI offer contingent on the packet.
Well, there's no offer. We'll put a PTI. Once we look at the mitigation packet, we'll determine if we're willing to make an offer of PTI.
So how long do you want? What was the last name again?
I'll be attached to the case today, so I can.
He's here, right?
Yes, he is.
Lee Hughes, come up.
I went outside and talked to him, so he's standing right there. She's going to get him.
Okay, great.
You doing okay?
Doing great. Thanks, you.
Seems like everybody has this little nasal deal.
My daughter suffers, man.
Trying to get on the other side.
Come on up, Mr. Hughes. Your lawyer is trying to work a deal where he's trying to get an intervention agreement for you. You need to turn in what's called a mitigation packet to try to secure that kind of agreement from the state. As with anything in life, you get what you put in. If you put your heart and soul into it, you can achieve damn near anything. But if you put something together, it looks like you did the night before on a bar napkin, don't expect much. He's going to ask stuff for you. If you don't put your heart into it and soul into it, don't expect much. Do you understand?
Yes, sir.
Now, your case is 190 days old. I'm going to give you one last setting. You will not get any more time after this. I will give you 3 weeks, 4 weeks, but after that time, you're done. If you have not completed your side of the bargain, I'm going to set your case for trial. You get no more time. Do you understand?
Yes, sir.
Okay, you got 30 days. That's it. All right, we'll have you see.